Let's just jump right in with a question that really gets to the heart of the Indian Constitution.
Yeah.
When you look at all the different bodies set up to protect people, commissions for human rights, for women, for minorities, they're all critical.
Absolutely.
But they're all statutory. They're created by an act of parliament.
And an act that can be changed.
Exactly. And then you have the National Commission for Scheduled Castes. It's not statutory. It's right there, baked into the Constitution itself in Article 338. Why?
And that why is everything. I mean, for anyone seriously trying to understand Indian polity, especially if you're preparing for an exam like the UPSC, grasping that difference.
Constitutional versus statutory.
It's the key. It tells you everything about the foundational priorities of the framers. It shows you that the commitment to social justice for scheduled castes and scheduled tribes wasn't just an afterthought. It was seen as so fundamental, so non-negotiable, that it needed the highest level of protection the Constitution could offer.
So that's our mission for this deep dive. We're going to unpack that very distinction using M. Laxmikanth's Indian Polity, 8th edition, specifically Chapter 48, as our guide.
We're not just going to list facts. We want to trace the story, dissect the powers, and, most importantly for you, connect it all back to the kind of questions you'll actually face.
This is about understanding the why behind the what's.
Exactly. Understanding the NCSC isn't just about memorizing an article number. It's about seeing how it fits into this huge, complex machine of social justice and accountability in India.
Before we get into the history, though, we have to start with a really humble request for your support.
We really do.
To all of our existing members, a huge, sincere thank you. It is genuinely your support that allows us to produce this kind of in-depth content week after week. It just wouldn't be possible otherwise.
It really wouldn't.
So if you're listening and you find this valuable, and if you are capable, please consider subscribing and joining our paid membership on YouTube. And of course, please don't forget to like this video and share your comments. It helps more than you know.
It really fuels the whole project. And to help you with your studies, we've got resources ready. The free notes for this deep dive with practice previous year questions are already up on our Telegram channel.
And for our legend YouTube members, we've gone a step further.
Yes, on our Discord channel, you'll find premium notes. They have extra PYQs and even model answers for mains questions. It's all there waiting for you, so do join us there.
All right, let's get into it. The evolution of this body.
Yes.
Because the NCSC, as we know it today, it didn't just appear fully formed in 1950, did it?
Not at all. Its story is one of gradual evolution, of the system learning and adapting. It's a perfect example of the Constitution being a living document.
So take us back to the beginning, 1950. The Constitution is adopted. What was the original plan for safeguarding SCs and STs?
The original plan was, believe it or not, incredibly simple, maybe too simple. The Constitution didn't create a commission, it created a single post. The Special Officer for Scheduled Castes and Scheduled Tribes.
Just one person.
One person. Often called the Commissioner for SCs and STs. His job was to investigate all the safeguards and report his findings directly to the President. That was the entire constitutional mechanism.
That immediately begs the question, and this is a classic analytical point for an exam, why a single officer? For a country of India's size and complexity, that seems, well, insufficient.
I think the idea was probably rooted in a desire for direct accountability. You know, one person with a clear constitutional mandate reporting to the very top, no committees, no bureaucracy, just a straight line.
A single point of responsibility.
Precisely. But the reality on the ground quickly showed the flaws in that model. The sheer scale of the task, the geographical spread, the depth of the discrimination. It was just too much for one office to handle effectively.
So what were the specific failures? What couldn't this one officer do?
It was a problem of reach and resources. I mean, think about it. How can one central office in Delhi conduct meaningful, on-the-ground investigations in a remote village in Tamil Nadu or a town in Bihar?
You'd need a massive infrastructure.
You'd need regional offices, investigative staff, legal experts, social scientists, all things a single officer model just couldn't support. The reports were filed, and they often highlighted serious problems, but the institution itself lacked the administrative muscle to force any real change.
So the system was failing, and the government knew it.
Yeah.
What was the first step to fix it? Did they go straight for a constitutional amendment?
No, and this is a really important detail. The first steps were executive, not constitutional. They tried to patch the system without opening up the Constitution. In 1978, the government passed a simple executive resolution, not an act of parliament, just a government order. And with that, they created a non-statutory commission for SCs and STs.
So this new commission existed at the same time as the constitutional special officer.
Exactly, it ran in parallel. The idea was to give the special officer an advisory and consultative wing that he desperately needed.
A kind of administrative add-on.
You could call it that. And then, a few years later in 1987, they tweaked it again with another resolution, renaming it the National Commission for SCs and STs.
But still not constitutional.
Still not. It was entirely dependent on the will of the government of the day. It had no real independence or security. This entire period, from 78 to 90, shows this. This incremental struggle to build a better institutional framework.
Until finally they realized the patch wasn't going to work.
Right. They realized the problem needed a constitutional solution. And that brings us to the first massive turning point.
The 65th Constitutional Amendment Act of 1990.
That's the one. This was the landmark. The 65th Amendment did away with the old special officer model completely.
Gone.
It amended Article 338 and replaced the single officer with a high-level, multi-member National Commission for Scheduled Castes and Scheduled Tribes. For the first time, the commission had full constitutional status.
It was no longer just an advisory body set up by the government.
It was a constitutional authority in its own right, with all the power and permanence that comes with it.
This joint commission for both SEs and STs lasted for more than a decade. But then came another big change. Why was it separated?
It came down to a recognition that while both communities face historical marginalization, their specific problems are often very different.
Can you give an example?
Sure. For scheduled castes, the core issues often revolve around the practice of untouchability, social boycotts, discrimination in urban employment, and access to land in settled agricultural areas. For scheduled tribes, the challenges are very distinct. They're often about the alienation of land in scheduled areas, protection of forest rights, cultural preservation, and the unique administrative systems under the 5th and 6th schedules.
So a one-size-fits-all approach wasn't working.
Exactly. The feeling grew that a joint commission couldn't give the specialized, focused attention that each community deserved, and that led to the final big structural change.
The 89th Constitutional Amendment Act of 2003.
Yes. This amendment bifurcated the joint body. It split it into two separate, equally powerful constitutional commissions.
And what are those two bodies now?
The National Commission for Scheduled Castes, or the NCSC, which continues to exist under the original but now amended Article 338. And the National Commission for Scheduled Tribes, the NCST, which was created under a brand new article inserted into the Constitution, Article 338AA.
So the separate NCSC we're talking about today officially came into being in 2004.
That's the timeline. And it tells a fascinating story, doesn't it? From a single, under-resourced officer to these two highly specialized, powerful, multi-member constitutional bodies, that journey itself is a key takeaway.
Okay, so that's the how and why of its creation. Let's get into the mechanics, the nitty-gritty. What does this commission actually look like? Who is in it?
The structure is designed to give it significant weight. It's a multi-member body with a total of 5 people.
5.
You have a chairperson, a vice chairperson, and then 3 other members, and all 5 are appointed by the president.
Not by the government or a minister.
No, directly by the president, by a warrant under his hand and seal.
That sounds very formal. Is that significant?
It's hugely significant. It's the same formal process used for appointing, say, a Supreme Court judge or the Chief Election Commissioner. It signals that their authority comes directly from the head of state, which reinforces their independence from the executive.
Okay, and what about their term? How long do they serve?
The president determines the specific conditions of service and their tenure. Under the current rules, they hold office for a fixed term of 3 years.
3 years. Can they be reappointed? This feels like a classic exam question.
It is, and the answer is yes, they can be reappointed, but, and this is the crucial part you have to remember, they are not eligible for appointment for more than 2 terms.
So a maximum of 6 years total?
A maximum of 6 years. It ensures that there's a rotation of leadership and prevents any single individual from becoming too entrenched.
Right. We know who they are. Now, what do? The source material lays out 6 core functions. Let's break those down.
We can think of them in a few logical groups. The first 2 are really about oversight and fact-finding.
Okay, what's the first one?
The first is investigation and monitoring. The NCSC's job is to look into and monitor everything related to the constitutional and legal safeguards for SCs. They have to constantly evaluate if those safeguards are actually working on the ground.
If they find a problem or if someone brings a problem to them.
That leads to the second function, inquiry into complaints. The commission has the power to investigate specific, individual complaints about someone being deprived of their rights. This is where it goes from broad policy monitoring to delivering justice in a specific case.
So it's both a watchdog and a grievance redressal body.
Precisely. The next function then shifts from looking at the past to planning for the future.
Which is?
Planning and advice. The NCSC has to participate in and advise on the socioeconomic development planning for SEs. It also evaluates how well those plans are working, both at the union and state level. This gives it a seat at the table when policies are being made.
So they're not just reacting to problems or trying to prevent them.
That's the idea. Then, of course, they have to formalize all this work.
The fourth function. Reporting.
Right. They have to submit reports to the president on how the safeguards are working. This is usually done annually, but they can submit a special report anytime they feel it's necessary.
And after they've reported the problems, they need to suggest solutions.
That's function number 5, recommendations. The commission makes specific recommendations to the union and state governments on what measures they should take to better protect and develop the SC's community.
And finally, there's a sixth, more general function.
Yes, a kind of catch-all. It says the commission will discharge any other duties related to the welfare and advancement of SCs that the president might specify. It gives the body some flexibility to adapt to new challenges.
Now, this is all very important, but it could sound like just another advisory body. What gives the NCSC its teeth? What's the enforcement mechanism?
This is probably the most critical detail for you to understand. When the NCSC is investigating any matter, it is vested with all the powers of a single court trying a suit.
Okay, let's break that down. Powers of a civil court. What does that mean in the real world? Let's say they're investigating a complaint of discrimination in a university.
Great example. So the first thing they can do is ensure people show up. They can issue a legally binding summons
To anyone.
to any person from any part of India. They can summon the vice chancellor, the registrar, the clerk who handled the files, and force them to attend the inquiry and give evidence under oath.
And if they don't show up?
It's treated like contempt of court.
Wow. Okay, so they can get people in the room. What about getting documents?
That's the second power. They can require the discovery and production of any document. In your university example, they can demand the recruitment files, the selection committee minutes, the reservation rosters, everything. They can cut right through the bureaucracy.
Which is often where the evidence of discrimination is hidden.
Exactly. The third power is that they can receive evidence on affidavits, so they can take formal, sworn testimony. Fourth, they can requisition any public record from any court or government office.
So they can get police reports, land records, anything they need.
Anything. And fifth, they can issue summons just for the examination of witnesses or documents. It's a comprehensive set of investigative powers. This is what turns the NCSC from a simple advisory panel into a powerful quasi-judicial authority. Its findings aren't just opinions. They're based on legally compelled evidence.
That's a huge distinction. Okay, now let's zoom out a bit and connect this to the broader picture. The kind of analysis you need for the mains exam.
Yes, the contextual linkages.
We started by saying its constitutional status under Article 338 is key. Why does that matter so much more than being a statutory body like, say, the National Human Rights Commission?
It provides a level of protection and authority that a statutory body just doesn't have. The first is permanence.
Meaning?
To change the NCSC's mandate or even to abolish it, you would need a constitutional amendment, which is a very difficult political process. A statutory body like the NHRC can be changed or even dissolved by a simple majority in Parliament.
So it's much more secure.
Much more. And it's also more independent. The appointment by the president, the fixed tenure, it all insulates the commission from the day-to-day pressures of the government in power. A statutory body is often more beholden to the ministry that created it.
Okay, so its status is superior. Now let's link its actual work to the rest of the Constitution. Its mandate is to investigate the deprivation of rights. That sounds like it connects directly to the fundamental rights.
It does. It's the enforcement machinery for several fundamental rights, specifically for the SC community. Let's take them one by one.
Start with Article 15.
Article 15 prohibits discrimination on grounds of caste. The NCSC is the primary body that investigates complaints of this kind of discrimination. If an SC family is denied housing or access to a public well, it's a violation of Article 15, and the NCSC is the body they can go to.
What about public employment and reservations?
That's Article 16. A huge part of the NCSC's work is monitoring the implementation of reservation policies for SCs in government jobs.
So they check if the quotas are being filled correctly.
Exactly. They audit the reservation rosters, investigate complaints about promotions, look into why there are so-called backlog vacancies. They are the watchdogs for Article 16 in action.
And when we talk about Article 16, we're also in the territory of major Supreme Court judgments, like the Indrasani case.
Right. And while that case was primarily about OBC reservations and the creamy layer, it established the legal framework for affirmative action that the NCSC operates within. You have to understand that broader context.
Of course. Now, what's the most direct, historically significant, fundamental the NCSC is tasked with protecting?
Without a doubt, it's Article 17, the abolition of untouchability.
The absolute core of the issue.
It's a constitutional command to end a historical injustice. The NCSC's role is to monitor the enforcement of the laws that were passed to give teeth to Article 17.
Like the Prevention of Atrocities Act.
Precisely. The Protection of Civil Rights Act and the SCST Prevention of Atrocities Act. The NCSC investigates violations under these acts, making it a frontline institution in the fight against untouchability.
So that's the link to fundamental rights. What are the Directive Principles, the DPSPs?
The connection there is just as strong, particularly to Article 46.
Remind us what Article 46 says.
It directs the state to promote the educational and economic interests of weaker sections, especially the SCs and STs.
So it's about proactive development, not just preventing harm.
Exactly. And this ties directly into the NCSC's function of advising on socioeconomic planning. The Commission acts as a constitutional nudge, constantly reminding the government of its duty under Article 46 and evaluating whether its development schemes are actually reaching the intended beneficiaries.
The source material brought up a past mains question about the fifth schedule and left-wing extremism.
Yeah.
Now, the fifth schedule is about tribal areas, so that's the NCST's job, not the NCSC.
Correct.
Well, what's the broader lesson we can draw from that connection for understanding the NCSC?
The theme is universal and incredibly important for Maine's answers. The question basically links the failure to implement constitutional safeguards for a vulnerable group, in that case STS, to a breakdown in law and order and even national security.
I see.
The lesson is that these commissions, whether it's the NCSC or the NCST, are not just about social justice. They are critical pillars of good governance. When these bodies fail, or when their advice is ignored, it leads to alienation, anger, and a loss of faith in the state itself. That creates a vacuum that can be filled by extremist ideologies.
So a functional NCSC that effectively protects the rights of SCs is also contributing to social harmony and national stability.
Absolutely. That's the bigger picture you need to see. These aren't just siloed commissions. They are essential for the health of the entire democratic system.
All right, so we've seen how the commission investigates and what its constitutional role is. Let's talk about the final stage, accountability. What happens after they write a report?
This is where the constitutional design really shines. The reporting chain is what gives the commission's work its political impact.
So the NCSC compiles its report, full of findings and recommendations. Who gets it first?
It goes straight to the top. It's submitted directly to the President of India.
And what does the president do with it?
The President is constitutionally required to cause the report to be laid before each House of Parliament.
So it has to be debated in the Lok Sabha and the Rajya Sabha.
It has to be tabled. And it's not just the report. It's accompanied by what's called an Action Taken Memorandum, or ATM.
An ATM.
Yes, where the government has to explain what action it has taken on the Commission's recommendations.
That forces the government to respond publicly.
It does. But what if the report is about a specific state? The central government can't do everything.
Good point. So how does it reach the state level?
The Constitution has a mechanism for that. A copy of the report is sent to the governor of the concerned state.
And the governor's role is similar to the president's.
Exactly. The governor must then cause the report to be laid before the state legislature.
Along with a similar action taken memorandum from the state government?
Yes. And here's the crucial part. If the state government has decided not to accept a recommendation from the NCSC, it has to state its reasons for the non-acceptance in that memorandum.
So they can't just ignore it.
Yeah.
They have to publicly justify why they are disagreeing with a constitutional body.
That's the accountability loop. It's a system of transparency and political pressure. It's very similar to the way the reports of the CAG, the Comptroller, and Auditor General are handled.
This brings us to a critical question, though. We've established the NCSC's recommendations are generally advisory, not legally binding orders.
Correct.
So if a government can just give a reason for rejecting a recommendation, What's to stop them from just ignoring the NCSC's work? Where are the real teeth?
The teeth are not judicial, they are political. The real power comes from that mandatory requirement to place the report and the government's response before the legislature.
The power of public scrutiny.
Exactly. No government wants to stand up in Parliament or a state assembly and repeatedly have to explain why it is ignoring the findings of a constitutional body set up to protect the most vulnerable. It creates immense political pressure from the opposition, from the media, and from the public.
So the enforcement mechanism is transparency and legislative oversight.
That's the design. It compels the executive to engage with the Commission's findings and drives continuous action.
When you put it all together, the existence and functioning of the NCSC seems to be a perfect example of the idea of a welfare state.
It is the embodiment of it. A police state is just concerned with law and order. A welfare state is actively concerned with creating a just social order and promoting the welfare of its people.
Fulfilling the promises of the preamble.
Justice, liberty, equality, fraternity. The NCSC is the institutional machinery designed to make those words a reality for those who have been historically denied them. It's the state moving beyond just passive non-discrimination and taking active steps to ensure development and protection, which is the very essence of Article 38 and Article 46 of the Directive Principles.
So it's a quasi-judicial body using a political accountability mechanism to achieve the socioeconomic goals of the Constitution. It's a powerful combination.
It is. When it works as intended, it's a formidable tool for social justice.
Okay, that was a really comprehensive deep dive. Let's try to boil it all down to the absolute must-remember takeaways for anyone studying this.
I think number one has to be the constitutional status. Remember, it's Article 338. Remember its evolution from a single special officer and its bifurcation from the NCST in 2003. That journey is crucial.
Right. The constitutional anchor is everything. My key takeaway would be the powers. You have to remember it has the powers of a civil court.
Yes, that's what gives its investigations legitimacy and force. It can summon people and demand documents. It's not just a committee writing opinions.
And my final one would be the accountability loop. That chain from the NCSC to the president or governor and then to the floor of the legislature. That's how its advisory recommendations get their political bite.
And I'll add one more. Always link its functions back to the core articles. Link it to Article 15 on discrimination, Article 16 on reservations, Article 17 on untouchability, and the goal of Article 46. That's how you build a complete analytical answer.
Perfect. That's the foundation you need to master this topic.
So to leave you with a final thought to chew on, something to reflect on after this.
Please.
We've established that the Constitution gives a special, superior constitutional status to the commissions for scheduled castes and scheduled tribes, while bodies for women, minorities, or human rights are statutory. The question to ask yourself is, why? What is the deeper historical, political, and social reason for giving this constitutional supremacy only to the bodies dealing with SCs and STs? Ponder on that. Does it reflect a recognition that the nature of caste-based discrimination is so deep, so historically entrenched in society, that it requires a more permanent, a more unassailable institutional remedy than any other form of injustice?
That is a fantastic question to think about. It really gets to the core of what makes the Indian Constitutional Project unique.
Indeed.
Well, this has been an incredibly insightful deep dive. Thank you, the learner, for joining us and for staying with us through this detailed exploration. We hope it's really clarified this important chapter for you.
We really do.
And before we sign off, just one last sincere word of thanks to all our members and supporters. We really can't say it enough. Your contributions make all of this possible.
They are the foundation of this project.
So if you're able and you found this valuable, please do consider subscribing and joining the paid membership on YouTube. And of course, a like and a comment go a long way in helping the channel grow and reach more learners like you.
And don't forget the notes. The free version with PYQs is on Telegram. And for our legend YouTube members, the premium notes with Model Main's answers are waiting for you on Discord. Make sure you take advantage of those resources.
Keep digging, keep questioning, and we'll catch you on the next deep dive.